Welcome everyone. This is Amer from UCounsel. In our previous lecture, we provided a brief overview of the discovery process in a civil action in Ontario. In today's lecture, we'll talk about discovery plan. This is one of the most important steps in the discovery process, and we'll explain to you what a discovery plan is about. We begin again with our usual disclaimer that this lecture is not legal advice. So if you have any specific questions about your issues, you should contact a lawyer or a paralegal or contact the Law Society of Ontario for a referral. What is the discovery process? We had explained this in detail in our previous lecture, but just as a recap, a discovery process is a process whereby you as a party can obtain evidence from the other side with respect to the relevant issues in the action. So all parties are entitled to obtain evidence from the other side prior to going to trial so that they are aware of what kind of case they have to meet. If you haven't watched the previous lecture, I would suggest that you do so that you have an overall understanding of the discovery process and then come to this lecture. So discovery plan, what is a discovery plan? A discovery plan is an agreement between parties. So it's an agreement between all parties in the action. If there are more than two parties, then the agreement should be between all of the parties. What is this agreement about? It deals with the discovery process itself. There are different facets of the discovery process, and you want to discuss all of those in your discovery plan. The agreement must be in writing, and the agreement must be completed, the discovery plan must be completed within 60 days of close of pleadings. Close of pleadings is a specific term in the rules of civil procedure. I believe it's rule 25.05 or something or thereabouts. You can look it up. But essentially, what is meant by close of pleadings is it's a time when the party that is supposed to serve and file their reply, they have done so. So if you are the plaintiff and you have received your defense and now you intend to file a reply, once that reply is served and filed, then that's the time that the pleadings are closed. Or if you chose not to file a reply, then the time during which you could have filed a reply, that time has expired. And also, if there are any defendants that did not file their defenses and they need to be noted in default, that step has been taken place. So it's an important step. Excuse me. And so you need to understand when the pleadings is closed. And when the pleadings are closed, you have 60 days. During that time, you have to complete a discovery plan and get all parties to an agreement. The 60 days time period can be changed with agreement of parties. So if parties mutually decide that a discovery plan will be completed in, let's say, 90 days of the close of pleadings, then that's fine. The court will accept that. What is contained in a discovery plan? First of all, the discovery plan should contain the intended scope of documentary discovery. What kind of documents are the parties going to provide? And so how do you determine what is the intended scope? You have to consider four elements. Number one, relevance. Relevance is sort of the most important aspect of documentary discovery because only documents that are relevant to the issues in the action are required to be produced. The documents that are not relevant need not be produced. And I had given an example in the previous lecture where the example we took was that you're commencing a court action, or you have commenced a court action against your contractor who was renovating your kitchen, and you believe that the contractor did not do the job correctly and caused you damages, and you are suing the contractor for those damages. So the relevant issues could be, in that specific case, could be whether you had a contract or not with a contractor. What was the content of that contract? What was it that was agreed upon? If there are any email correspondence that you exchange with contractor and contractor has possession of those emails, then those are relevant documents that you are entitled to have. If you exchange any text messages, for example, with the contractor with respect to the particular issues in the action, then you may be entitled to have those text messages produced. There may be charts, diagrams that may be in the possession of contractor that are relevant. They may be relevant documents and ought to be produced. There may be photographs. There may be audio recordings. So things of that sort. So any document that is relevant to the issues of the action becomes relevant. So you determine with discussion with the other side or other sides what is the scope of documentary discovery. What is it that they will go back and look for with respect to relevant documents and then produce those. You also discuss the cost. So you have to keep in mind that the documentary discovery is not an infinite right. It is the term that is used in the rules of civil procedure is called proportionality. Proportionality is an important part, and I'll talk about it later on in the lecture. And then the importance of documents that you're asking the other side to produce, and also the complexity of your case. So these are some of the things that you consider in deciding the scope of documentary discovery, and then that scope of documentary discovery should be in the discovery plan. You also need to agree upon the dates on which the parties need to exchange their affidavit of documents. I believe I have a separate lecture on affidavit of documents, what they are. You can look them up, but these are documents that contain a list of all the relevant documents that a party has in its possession and provide it to the other side. You also need to discuss the timing, cost, and manner of production. So affidavit of document only contains a list. Now, if the other side requires you to produce the documents that are in part of the list, then how, number one, when do you need to provide those documents? Usually, parties agree to exchange the productions at the same time when the affidavit of documents are exchanged, but that may not necessarily be the case. You may agree on a different date. Who's going to pay the cost of the documentary production? Is each party going to bear its own cost? Are you going to pay the cost of documentary production that you are asking the other side to do? And then what is the manner of production? Do you require paper copies of everything bound and tabbed? Or is the electronic production of documents sufficient? Which in most cases may be okay. You put those documents on a USB stick in PDF form or another common format and then provide it to the other side. So all of these items need to be discussed in a discovery plan. Names of persons to be examined. So who are the individuals that you will be examining, or an individual that you will be examining from the other side or sides, and similarly who will they be examining from your side. So that needs to be agreed upon. And then any other items that can move this discovery process expeditiously and cost effectively, that all need to be put in the discovery plan. Some of the additional considerations that you want to keep in mind with respect to discovery: if there are any changes to your discovery plan that happen by agreement of parties, then you need to update the discovery plan and keep it updated. You do not need to file it with the court. You need to have it available. You bring it to the court only if there are issues with respect to the discovery process and you're bringing a motion seeking some order from the court, and you need to rely on a discovery plan that was agreed upon. Then you can go back and provide the discovery plan to the court. If you don't agree to a discovery plan in the time period that is provided, or do not agree at all, and if you are seeking any remedies under Rules 30 to 35, which are remedies with respect to discovery process, then the court may refuse to grant you your remedy because you have not agreed on a plan. Now, again, if you wanted to agree to a plan but the opposing side was being unreasonable, then that could be an issue that could be brought to the court and you can obtain an order. But generally speaking, if you have not done your part in agreeing to a discovery plan, then you may not get the remedies that you want the court to give you under these rules. Proportionality, as I said, is an important principle in the court actions in general, and also with respect to the discovery process. It is in Rule 29.2.03. Let's see if I can take you there, and then we'll go over it quickly. Right here. So when you ask a party to provide certain documents, and let's say they do not provide it, and you bring a motion to the court and say that you want the court to give an order to the other side to provide those documents, what is it that the court is going to consider whether those documents ought to be produced or not? First point is the time. How long would it take for that party to get those documents and produce those documents, and is that time frame unreasonable? Expense. How much is it going to cost the other side to answer the production of those documents, and is that cost, is that expense unjustified, right? Then requiring the party or the person to answer the questions or produce the document would cause him or her undue prejudice. If there's any prejudice that may be caused to that party, and this could be, all kinds of things in commercial circumstances. Maybe the production of those documents may cause some economic harm. That could be an argument, but that is something that can be brought up for the consideration of the court, and the court can rule accordingly. Requiring the party or the person to answer the question or produce the document would unduly interfere with the orderly progress of the action, and the information or the document is readily available to the party requesting it from another source. So you are asking somebody to produce that document, but you could obtain it yourself. Then the court may say, look, we're not going to give you this order because you can go ahead and get it yourself. And then also the court considers overall volume of documents. If your case is worth, let's say, $50,000, and you believe that the relevant documents in this case are, 20,000 documents, then the court may say that request is completely unreasonable because it is disproportionate to your claim and the complexity of your claim. So what is it that you want to keep in mind? You want to carefully review the rules to understand what are the rules about a discovery plan, and you want to make sure that you agree to a discovery plan. You carefully draft it, the discovery plan, to make sure that it covers all of the important issues that need to be agreed upon, and then parties have an agreement. And with respect to agreement, just so you know, there isn't really a specific form or format that you need to follow with respect to the discovery plan. It really depends upon the circumstances of your case, the complexity of your case. It could be done in email correspondence as long as there is an agreement between parties. In a lot of my cases in employment law matters, I tend to agree to a discovery plan just by email correspondence. You could even do it by text messages. So as long as there is a written document that confirms the agreement of parties with respect to the discovery process, then you're fine. It does not need to be signed by parties as long as there is an agreement. So you want to make sure that you want to carefully draft the discovery plan, and keep in mind the proportionality. It's an important principle. The court will carefully review whether what you're asking or any side is asking is proportional to the issues in the litigation, complexity, the cost, the damages claimed. All of those factors are considered by the court. Now there's a sample discovery plan. It is provided by Ontario Bar Association, which is the association representing lawyers in Ontario, and it's an excellent discovery plan, and I'm just going to show it to you. You can go on their website, download it if you want a discovery plan, and you can use it. This is just a sample. This is not sort of a legal form given by OBA, so do not treat it as a legal document provided by them. But you notice that this is just like any of the court forms. You provide the title of the proceeding on the top, then it says discovery plan. And first item talks about applicable procedural regime, whether it's a commercialist matter, simplified procedure, what kind of action is this? What are some of the legal issues for determination at trial? You talk about the causes of action. What is it that you're claiming? Is it a breach of contract? Is it a defamation case? What is the nature of the case? What kind of legal issues will be raised under each cause of action? And what are the head of damages that are claimed? So you can briefly talk about it. You don't need to do this, but this is sort of a very broad and comprehensive form that gives you some guidance. You don't need to necessarily follow all of these steps. Scope of documentary discovery, yes, you have to make sure that the scope of documentary discovery is to be agreed upon. And so you will see here the identification and priority of the documents and their authors. So identify and prioritize key authors and custodians, record types, emails, electronic forms, other documents, relevant timeframes, location, and other parameters within which search will be conducted for relevant records, right? So once you agree upon, so I'll give you an example. So you may say in the same case of a contractor, you may say that you agreed to this project. You had preliminary discussions from September of 2018 till end of October of 2018, and then you entered into this agreement with the contractor. Then the scope of your documentary discovery could be, any emails that I exchanged with you from September 1st, 2018 to present time, or to December 31st, 2018, and that could define the scope, the time frame, right? And then these could be emails exchanged between you and the contractor. Or if the scope needs to be widened because there were other people that had communicated by email from the contractor's office and you want to encompass those emails as well, then you expand the scopes. Then you say all email correspondence between contractor's office and myself from the time period of September 1st to December 31st, 2018. So that's why it's important to consider what kind of documents are required, what kind of documents the other side may have, who could be the authors and custodians of those documents, so that you are able to get all relevant documents and don't miss out on documents that may be relevant and you have not asked for their production. And then in this step, you agree to the deadline for Affidavit of Documents that we discussed, and then timing and the format of production of records and how do you do it. Then you talk about oral discoveries, when will these be conducted, who will be attending, and if there are other forms of discoveries, how do we go about doing that. So this is a form that you can use. I've provided the link. You can go to that link and download this form and use it based upon the circumstances of your own case. So the fundamental idea of discovery plan is that it's a written document that provides an agreement between parties on how the discovery process is going to take place. So who is going to provide documents when, who is going to be examined, who's going to pay for cost, and this needs to be done as soon as possible within 60 days of close of pleadings, and if not, then whatever time frame is agreed on between parties. In the following lectures, we will again proceed with other smaller distinct steps in the litigation process. So for example, we'll talk about the examination for discovery. I'll explain to you what kind of forms you require to serve on the other side for the examinations, how do you know what is contained in those forms and whatnot. So we'll take apart this discovery process piece by piece and provide you at least some overview so you have a broader understanding of the discovery process, and then you are able to effectively conduct your discoveries on the other side. Thank you for watching. If you have any questions or comments, please share with us, and I look forward to seeing you in the next lecture.